Have you gotten your company to the point where you're ready to trademark and you're looking at how you can do the process yourself? Well, the problem is that can sometimes cost you a lot more money, a lot more time, and a lot more headaches than it would be if you actually had an expert to do it. Hi, I'm Samantha, a small business and trademark attorney. My whole goal in being on this corner of the internet is to help you figure out the best way to protect your intellectual property and make more money off of it if we can. So in this video, I'm actually going to show you some of the common pitfalls for DIY trademark applications and maybe some ways that you can think of avoiding them so we don't have to take more time, more money, and more headaches for you to get your intellectual property.
Welcome back to my office. We're going to bounce back and forth between Perianopolis and here for this video, I think. So if you want to avoid expensive errors, we do have a trademark quiz that will help you figure out if it's a good likelihood that you'll get return on investment from a trademark application at all, if it makes sense for you, and if your brand name, if your company name, your signature service or product name is unique enough to actually be deemed trademarkable by the U.S. Patent and Trademark Office. Let's get into it. Here's the thing, even a tiny typo can derail your entire trademark application, right? One misplaced letter and your application gets rejected or you get office actions. And here's the trick, you won't even know about any of that for months. Right now, it's taking 7.5 months to assign a person to your file to review the application. You won't even know if you've messed up until over half a year from today without having guidance that the application was correct. If you can afford to wait that long, then no big deal. But if those 7 months could make or break, your ability to get a licensing deal, expand into a market, or a million other ways that you can make more money with having a trademark than you can without. By the way, we talk about that here, so you should check out that video in more detail. And you figure out later on that something's messed up, most of the time, you're going to get something called an office action, which sounds like a big, scary thing, and it can be complicated to figure out. So you either have to figure out how to respond to it or reapply and pay all of these non-refundable government fees again, because it costs hundreds of dollars per category to apply for protection for a trademark for your brand. Speaking of each category, did you know there's 45 of them? Let's go talk about it back in Perianopolis.
Did you know that as a business owner, if you're getting ready to apply for your trademark, there are 45 different categories of things that you actually have to claim you are trying to protect your brand in? What do I mean? I'm here in Perianopolis. It's kind of a land of gemstones here in Goiás, Brazil. And we're at a beautiful gem store that's been nice enough to let us film in here. When it comes to U.S. trademarks, each one of these is a different category, right? Each one of these boxes is a different category of stuff that your company is allowed to sell exclusively under the brands that you're trying to protect with your trademark. For example, some of the categories in the trademark classification system are paper goods and leather goods. If you're an online coach that's selling journals, you're probably going to say, of course, paper goods. Let's make sure we protect paper goods. And you're going to be like, cool, I got it. I got my trademark in that. But if you don't make sure that you're adding enough different categories, when you decide that your company wants to expand into leather goods, you don't have the protection for that, which means you've restricted your company to only making paper products. If somebody shows up and opens the same journal that you're doing in leather goods, it's not your protection. We've created a weak trademark. So making sure that you're working with someone who understands not only where your brand is now and what you're selling now, but specifically if you want to expand into paper goods, leather couches, coaching services, speaking opportunities. So that way we create protection for the entire business that you want to make money from, not just the one that you're selling today.
Okay, now that we're back, I want to talk about how missing this one essential step can actually mean you've wasted hundreds of dollars at a minimum, even if you're DIYing, and you're alerting competitors to your brand. So the big thing that you do, that you get when you work with a trademark attorney, or at least as with my firm as your trademark attorney, is that we do a massive search before we ever even file on all these non-public databases to figure out if the brand that you want to apply for, the mark you want to apply for, the thing, the identifier that you want to apply for is already in use by somebody else. So what we do is we do this massive search on non-public databases to see if there's a good chance of your application even being registered. Why is this important? Because if there's already somebody else using your brand name and we apply, because the entire application process for the US Patent and Trademark Office is completely public, we are alerting somebody who might already be using the brand name that you're using, right? They were there first, they just didn't register, to the fact that you exist, which can create a problem within and of itself, right? They can come now and tell you to shut down, rebrand, force you to change all of your marketing material. The second problem is if we don't do that and it's a high risk application, we're essentially throwing money at the US government that we don't need to be, because like I said, for each category, the fees are hundreds of dollars for everything that we want to protect. So we want to make sure that we're putting you in the best situation to not be throwing money to the government that you don't need to. Because let's be real, we make enough money already, right? So if you want to avoid the pricey refiling or filing and having a competitor that has a brand name similar enough to yours that it's a problem, try to shut you down a couple weeks later, you can go ahead and take our quiz. It's linked below in the description. It will help you avoid this situation, right? Even before you think about actively applying. Now, let's get on to the biggest point of all, that saving money by doing DIY applications might cost you less now, today, on the day of your application. But the reality is, it's going to cost you more time, more money later in fixes, office actions, having to reapply, or maybe even starting a litigation process. So let's look at a straight up comparison. If you hire a decent trademark attorney, you're probably looking at like a $3,000 fee. There's some wiggle room here and there depending on where you live, because the cost of living in cities are different. For most attorneys, that's going to include at least one of those category of fees, and they're going to make sure it's the strongest one for you and your brand. That's also going to include that non-public search, at least it does for us, and a letter telling you what the risk level is for your brand. And it includes all non-substantive office action, which mean any small fixes that we can make without having to essentially write a big paper that's a legal argument. Then we take care of all of that for you. This process, from start to finish on an easy application, takes about 1.5 years. And we're covering all of that time for you. Every letter that comes in from the USPTO, we handle it. You don't have to figure out what it means. We translate it for you into non-legalese and then tell you that we've already handled it for you. And because the US Patent and Trademark Office application process for trademarks is completely public, scammers love to pretend like they're the USPTO and tell you have to apply for another thing or pay them more money. When you have a trademark lawyer, we are the only person the US Patent and Trademark Office will actually communicate with on your trademark application. So you can know for sure that anything you get over email, in the mail, and over the phone, because yes, they're spoofing the USPTO office phone number at this point. Like, the scammers have gotten good, y'all. You can know for a fact they're all scams, and you can know for a fact that it doesn't matter what they say. We're taking care of it for you. Now, if you do the DIY route, remember, we've talked about the fact that literally one letter can change things. And if we don't get your categories right, we've given you a weak trademark, and you're not going to find any of that out for a couple months. You may also choose a bunch of extra categories that you don't need, or you can wind up not choosing enough categories. You've gotten away from having to pay this amount, but now, because you're trying to figure out what the USPTO website, which is not an easy website, by the way, it wants you to choose for your categories. You've chosen 4 different categories when you only needed 2. There's about $700. Also, maybe when you were submitting the evidence that you have to submit to show the US Patent and Trademark Office that you're actually using your brand, you weren't aware that when you took the screenshot of your website, you actually had to show the date over here on the screenshot somehow. On an Apple, on a Mac, you actually have to turn on a function to make that work. Or you want to clear everything at the bottom of your computer so it doesn't show the 10 million tabs you have open on a Windows when it actually shows you the time down in the bottom right. And they rejected your application because of it, saying that you have to fix this. You now have to pay money to fix it, wait months to figure out that you need to fix it, and then pray that nothing changed on your website in the meantime, or the whole application could be thrown out and you start the process again. So now we're looking at adding maybe another 1.5 years and a whole nother set of category fees. So let's say it was the 2 that we definitely did need. There's $700, right? And then you didn't do the search and somebody else comes up and it turns out they're using a brand name similar to yours. It was a high-risk application to begin with. Now they're on alert that you're using it. You get a nasty lawyer letter saying, we want the profits from everything you've made since you started using this brand name. You're now having to write a check to somebody else or hire a lawyer to fight it out. That's going to cost you probably more than the check in some cases, when we could have done this search and figured out you were high risk and actually helped you to rebrand or come up with a coexistence agreement with the other company beforehand. Because now you've come to them asking for permission to coexist with them without having to pay them any more money, ideally, to do so. So we've gone from a pretty flat rate amount over here that it's pretty clear what you're going to get if it's, a reasonable application. And even if it's a hard application, we can help you make sure that we're adjusting it so it's not such a hard application. Or you can take the chance over here of, yes, pay less money now, but this could create problem after problem after problem later. Problems being an extra $700 for categories that you didn't need to choose, another $700 for resubmitting the categories that you've already paid for because you weren't able to get past the office action, potentially hiring a lawyer or paying the fee that somebody wants you to do because you figured out that your brand name was high risk to start with, and then rebranding down at the bottom anyway. This seems like a much easier and faster way to go. What do you say?
So, if this video made you think that you don't even want to risk any of the issues that I've brought up in the past couple minutes, you don't want to waste your time, you don't want to waste your money, and frankly, you just want to get this process done and move on to having intellectual property that can make you more money, then I would 100% recommend that you take our trademark quiz, which you can find below in the description. Why? It allows you to figure out if a trademark even has a return on investment for your brand, for your company, and it tells you how trademarkable the phrase, the name that you're thinking of using for your brand is. And this normally takes 45 minutes with a lawyer and a paid consult, and we're gonna let you do this for free in 10 minutes. So what I'd love for you to do, go take that quiz, put your results down in the comments below and any other trademark questions you have. I'm here to help your business thrive. And if this was helpful, please like and subscribe, all the YouTube things, tap all the buttons, and we'll be here for you next time. Thanks.